Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Canadian Maritime Law Key Judgment 2013. Two Federal Court Jurisdictions SDV Logisticus Canada Inc. v. Diligence. The Export Development Corporations or EDC loaned money to two hotels companies to complete constructions of two vessels at the Davis shipyards in Quebec. The loan was secured by a first priority mortgage on the house under constructions, as well as all appurtenances of each of them, including machinery and equipment. EDC also registered a hypothec on the appurtenances under Quebec's Register of Personal and Movable Real Rights. 4 diesel generators were to be installed on this vessel during their constructions, as well as a lifting device. The shipyard hired the plaintiff or SDV to pick up the machinery in Germany and ship it to Canada. The generators and lifting device were picked up in Kiel and delivered to storage in the port of Hamburg, but were never shipped to Canada. The Davis Shipyard Company later ceased operations, but its successor company continued to pay monthly storage fees on the goods stored in Hamburg, while operating under the company's Creditors Arrangement Act. A new company later purchased Davis assets but ceased to make payment to SDV, or amounting to $134,000 for storing and warehousing the equipment. The two hotel companies defaulted on their loan agreement with EDC, resulting in EDC seeking to sell the unfinished hulls under the Canada Shipping Act 2001. A warrant for the arrest of the generators and lifting device was issued by SDV but was never served in rem. SDV released its warrant and amended its actions against EDC, turning it into a suit a personam for payment of the storage charge. SDV applied to the final court for an order to follow the sale of perishable of deteriorating property. SDV's motions was dismissed by protonotary Morneau on the ground that the court lacked jurisdictions to make the other suit, resulting in an appeal to a federal court judge. Scott G. upheld Morneau P.S. judgment, emphasizing that directionary orders of protonaries ought not to be disturbed on appeal to judge, unless they are clearly wrong or raise questions vital to the final issue of the case. The questions of jurisdictions in this case was one of law, attracting a standard of correctness, but contrary to EDC pretensions, the judge applying the standard was obliged to set aside the finding in first instance and conduct his own analysis. While it was clear that final court had a personam jurisdictions over cases dealing with navigation and shipping, including claims for warehousing arising out of the carriage of goods by sea. In this case, SDV had to contract for the storage concern with the new operator of the Davis shipyard or with EDC. The sole in personam dividend for the federal court to order the judicial sale of cargoes which have never been in Canada. There must be a statutory provisions granting the court power to force such a sale. Such a provision was found in the Canada Shipping Act 2001 Section 69 with respect to mortgage property not located in Canada, but SDV, unlike EDC, was not the mortgage of the equipment concerned. No equivalent provisions in the statute granted power to issue an order of sale in favor of SDV for the outstanding storage charge, so that its actions against EDC was now a purely in personam proceeding. The court therefore lacked jurisdictions to order the relief sought. In addition, there was no evidence that the cargoes concerned were actually in peril as they required to support an order of sale under Rule 379 of the Federal Court Rules on the sale of perishable or deteriorating property. SDV's appeal was therefore dismissed with cause. Her Majesty the Queen in right of the Province of Alberta v. Tony. This long but fascinating judgment addresses the questions of whether the federal court has in personam jurisdictions over the government of a Canadian province in a maritime trade claim. The Tony family sued the province of Alberta in the federal court, alleging that the negligent operations of a rescue boat owned and operated by the province of Alberta had caused the death of their 5-year-old daughter in boating accident on an Alberta lake. The trial judge upheld the federal court in personam jurisdiction against Alberta over the objections of the province, but which then appealed the ruling to the Federal Court of Appeal. The appeal was allowed in a split decision 2-1, near GA speaking for the majority and applying the standard of correctness. First, recall for basic principle. Parliament and the provincial legislature have adopted the premise that the Crown is prima facie immune from legislations, as expressed in both the Federal and Alberta Interpretations Act, where Parliament has authority to legislate in an area. A provincial crown will be bound if Parliament so chooses. There must be some legislative provisions in order to provincial crowns to be sued in the federal court, and the federal court must have jurisdiction over both the subject matter of the dispute and the parties. The majority know that the Crown was presumed not to be bound by legislation unless it was expressly named therein, or was bound by necessary implication, or unless it has waived its immunity from suit. As to express binding, Sections 222 of the Federal Court Act, granting the Federal Court concurrent admiralty jurisdiction between subject and subject as well as otherwise. Emphasis added did not, in the opinion of the majority, sufficiently express Parliament intentions to bind the province or to confer on the federal court in personam jurisdiction over the province crown, nor was such a proposition supported by case law which had construed those final word of Section 22 to mean that a general descriptions of the subject matter of concurrent jurisdictions was insufficient to displace the provincial crown's traditional immunity from suit in the federal court. So this is the end of the article. Don't forget to watch my previous video, and bye bye.